Hello, and welcome to this edition of Thursdays Live with Nevada Legal Services. I am Ray Gherkin, and I am currently with our Reno office. And joining me today is Liz Carmona. Hello, Liz.
Hi, everyone.
Today, we have planned to do some updates on our record sealing presentation because the laws have now changed. Well, I shouldn't say have now changed. The law will change slightly starting October 1st. So we're going to update everybody on the changes to the record sealing law in Nevada, but also provide our general overview of how to file a petition to seal your record. Again, we were having some technical difficulty today. So let me post a message in the chat for the other live stream so everybody knows where to find us. Okay. So again, we are providing legal information, not advice. We're not your attorneys. We're not creating an attorney-client relationship. So please just, as always, with all of our educational presentations, keep that in mind. This is our opinion. We are giving you information that we believe to be accurate. And, you know, this process can be very frustrating. So it is not fast. It can take, I mean, during coronavirus, we actually had to extend our timeline significantly because it was taking a lot longer to get through this process, but it can take at least 6 to 9 months. Depending on the situation, it could be longer, but you are in this for the long haul if you are trying to seal your record. So you have to be patient with this process. All right, so first, Nevada has criminal record sealing, not expungement. And I know that there are other states that have expungement laws, but it's important to realize that this is a state by state law. There is no sealing or expungement of federal offenses. So we are only talking about Nevada criminal activity and criminal history. If you have criminal history from another state, you do have to figure out what that state's law says. You can do about a conviction or arrest from the past, but in Nevada, we are talking about eviction sealing. What does eviction sealing, I keep saying evictions, criminal record sealing. What does criminal record sealing do? Criminal record sealing limits access to the record. So basically what it does when you seal it, you're basically shutting off people from being able to look at it. It does allow certain organizations, and we'll get into what agencies can see a sealed record. But for the most part, for running background checks for employment or housing, for the most part, you will have the ability to completely seal that record off from public view. The legal effect is, though, really significant. What it allows you to do is say that you have never been convicted of those crimes once they're sealed. So when you're applying for housing, when you're applying for employment, you are legally entitled to say that that conviction never occurred. It does restore some, but not all of your civil rights, and we will talk about pardons in a second. Expungement destroys the record. So again, it's a destruction of the record. Sealing only limits access to it. So please keep that in mind. In Nevada, we are talking about criminal record sealing. Pardons, okay. Pardons do not limit access to any record, except the law has changed, and we're going to talk about what that means. Pardons, though, are the only way that you can restore your gun rights in Nevada. So you will have to seek a pardon first if your criminal history deprived you of your gun rights and that's what you want back. You do have to seek a pardon first. In the past, pardoned records were not automatically sealed. You'd have to get the pardon first and then file a petition to seal the record. Now, with the law change starting October 1st, pardons can be automatically sealed. The Board of Pardon Commissioners can now report to the Department of Public Safety to indicate that somebody's has been granted a pardon. And with that report, that pardon, that record would be sealed. It also allows you, though, to file a petition to seal a pardoned record. And the pardoned record must be sealed unless the charges don't match. So if you have other criminal history that you're trying to seal, it's, you need to be clear that what you were pardoned for is the record that you're trying to seal. the pardon information has to match the criminal record. There is no fee to file this petition. And it would be, like I said, it must be sealed unless there's an error in some of the information, or you're trying to seal other records, not the pardon record. All right, so what does criminal record sealing mean? So criminal record sealing, again, allows you to put on a job or housing application that this crime never occurred. It will not come up on a Nevada background check. That's why we notify the Department of Public Safety after you see the order, and that's a long time down the process, but we'll actually talk a little bit about the process later on. Please note that the FBI does agree to also seal Nevada records. So when the FBI also keeps a database of criminal activity for people, they will seal their records of Nevada crimes. Please be aware, this is not federal crimes. This is only Nevada crimes that are reported to the FBI that the FBI has in their database. They will honor a Nevada court sealing order for that, but this does not apply to other states. It does not apply to federal crimes. It is only for Nevada crimes, but the Department of Public Safety automatically notifies the FBI, and that is part of the sealing process. The civil rights that you are restored to are to vote, serve on a jury, which of course everybody is so excited about that one, and to hold office. Again, gun rights are not restored. You need to go to a pardon for that. And please be aware that, again, this is Nevada's criminal history. So immigration courts can still request documents and can still see criminal records. You do need to make sure that you have, once the record is sealed, make sure you have copies of all of the important documents from your file, because once it's sealed, you cannot access it. The court, like I said, it completely seals it from public view. You would not even be able to access it once the court seals that record. So there are two other, and we're just going to make a quick mention of this. We're not going to go into much detail about it, but there are two other ways to kind of seal or get rid of other criminal activity. Decriminalized offenses. So marijuana, possessions of small amounts of marijuana was decriminalized. There is a separate process for sealing those records. It should be automatic. If you file a petition, the prosecuting attorney for the court that you got the charge in has 10 days to object. If the prosecuting attorney does not object, the court shall seal the record. Please be aware that there is no appeal for this. If the court denies it, you have to go to a regular record sealing petition. This is just a faster way to get a simple possession of marijuana charge sealed. It will not seal any other charges. If you have other criminal history, it's probably better off for you to seal everything together. But if this is the only thing you've got on your record, there is an expedited process for this. And Liz, I think we have a form for that. It is not on our website currently, but that is something that we can put on the website. So if you guys are interested in that, you can message us and let us know. And filing that petition is free. Filing unless you qualify for a fee waiver, it will cost money to file normal criminal record sealing petitions. If you've been convicted of sex trafficking or involuntary servitude or some sex trafficking related crimes, there is a way to vacate judgments for, you're not charged with sex trafficking. If you're a victim of sex trafficking or involuntary servitude, there is a way to vacate judgments related to those crimes that might have come attached to it, such as prostitution, solicitation, some of those other crimes that, as a victim, you may have been charged with. For those specific crimes, for victims of sex trafficking or involuntary servitude, you can actually vacate the conviction. So there is a process in the statute for doing that. And then finally, sex offenses cannot be sealed. So, one of the things that you can do if you are on this sex offender registry, there are ways to request reductions in the registration requirement. That is a whole separate section. We're not going to go into that today, but please note that sex offenses cannot be sealed. The only thing you can possibly do is try to get your registration requirement reduced. All right, Liz, take it away.
Thanks, Ray. So this is probably one of the most important things that we're going to go over today is eligibility. In order to seal your criminal record in Nevada, you have to be eligible to do so. And what it means to be eligible is that you have to make sure that every conviction on your record has met a certain required waiting period. And those waiting periods are different depending on what convictions are on your record. Now, the clock of this waiting period begins once you have completed the last sentencing requirement for that conviction. So say you were convicted of a category A felony and you only had to serve prison time, the clock of this waiting period would start on the date that you were released from prison. But say that you went to prison and then you were paroled and then you paid a fine. If that fine was the last sentencing requirement that you completed for that conviction, the clock is going to start on the day that you paid off that fine. So this is going to require that you, A, know what convictions are on your record, B, you have to know when you completed those sentencing requirements, and then C, you have to make sure that you've met all of these required waiting periods. So we'll go through this table row by row. So the first row includes crimes against children, felony DUIs, sexual offenses, and home invasions with a deadly weapon. If you have any of those convictions on your record, they are currently ineligible to be sealed. As we already went over, currently under Nevada law, you cannot seal those convictions. If you have any category A felony convictions, crime of violence convictions, or if you have a burglary conviction, those all carry a 10-year required waiting period. For any category B, C, or D felony convictions, those will have a 5-year wait period. For any category E felony convictions, those are going to have a 2-year wait period. For enhanceable misdemeanors, which include non-felony DUIs and non-felony battery domestic violence convictions, those are going to carry a 7-year wait period. If you have any convictions for a gross misdemeanor, misdemeanor battery, harassment, stalking, or violation of a temporary or extended order for protection, those are all going to carry a 2-year wait period. For all other misdemeanors and traffic violations, there's going to be a 1-year wait period. If you were ultimately acquitted or if the charge was dismissed, there is no wait period. Or if you have an honorable discharge under NRS 453.3363, there's no wait time. And then lastly on here, if the prosecution declined to prosecute, you either have to wait until the statute of limitations has run or 8 years after the arrest, whichever is sooner, or you can write a letter to the prosecuting attorney and ask them if they will allow you to seal that record early. So just a recap of this slide, make sure all of your convictions have met those required waiting periods. So Ray and I are going to talk about today the process for sealing Nevada criminal records. If you have anything out of state, as Ray already mentioned, we would advise you to consult with the legal aid organization in that state because for the most part, states do have different procedures for sealing records. We're only going to talk about the process for sealing state records. If you have any federal records, it's a little bit of a mystery. I know that federal judges do have the authority to seal federal records, but there's really nothing enumerated in the law as to how you go about doing that. So again, today we're only going to discuss how you seal state records. As we talked about, all of the convictions on your record have to be eligible, but if you have any minor traffic violations that any traffic tickets or anything you picked up that's traffic related within the past year, you can also include that in the petition. And those don't always have to meet that required waiting period. A judge is not going to seal your record if you have any active or open criminal cases or if you have any warrants that are currently pending. So make sure that all of your cases are behind you and that you've met all of those waiting periods. As I talked about, crimes against children, felony DUIs, sexual offenses, and home invasions with a deadly weapon are ineligible to be sealed. And lastly on here, if you received a dishonorable discharge from probation, you may still be eligible for sealing so long as you've met the other eligibility requirements. If you were acquitted, the court shall order the record sealed. As we talked about, there's no wait period. If you were acquitted, you can go right into this process. If your charges were dismissed, there's going to be no wait period. There is a difference though between a dismissal and if the prosecution declined to prosecute. So as I said, if the charge was dismissed, there's going to be no wait period. But if the prosecutor did decline to prosecute the charge against you, you have to wait until the statute of limitations has run, or 8 years after the arrest, whichever occurs sooner, or you can write a letter to the prosecuting attorney and ask them to allow you to seal that record early.
And just so people are aware, this is actually one area where the law did change a little bit. It removed acquittals from dismissals and prosecution declinations. So if you were acquitted, you actually, it has changed the language to shall seal. So that is a little bit of a, a better way, essentially, yes, if you are acquitted of a crime, you should probably be entitled to have that, the arrest records and all of that sealed. So you are eligible immediately after acquitted, and it is a stronger mandate to have it sealed. It is a shall seal. It is still permissive. It is a may for dismissals or if the prosecutor declines. And we'll get into a little bit about that distinction because it also changed some of the language for the main thrust of what we're going to talk about when we talk about the process for sealing convictions. But I did just want to highlight that acquittals are now, a little bit easier to seal if they weren't easy to seal before.
So some special considerations. So regarding diversion programs, if you attended a court-ordered counseling or substance treatment or any work program, the record may already be sealed. In Nevada, many court-ordered programs will automatically seal a record upon successful completion of that diversion program. Successful completion of a reentry program also reduces the wait time to seal that record to 4 years, and that's pursuant to NRS 179.259. Professional licensing boards and the divisions of insurance of business and industry may still view the record for licensing purposes or misconduct investigations. And pursuant to NRS 453.3365, there is a 3-year time frame for drug offenses, not for the purpose of sale, if complete terms and conditions of court and probation or parole. And hearing determines person rehabilitated or automatic after probation complete after NRS 453.3363. But the records sealed under this section will still be open to inspection by licensing agencies.
And just so everybody's aware, this is different. This is different from the agencies that can see sealed records. We're talking about diversion programs for the most part, drug courts, reentry programs. Unfortunately, these are still available by licensing agencies. When we talk about who can see sealed records completely, that is a little bit more limited. There are still some agencies that can see them, but it isn't as broad as these categories. So unfortunately, it's a nice benefit, but it does mean for licensing purposes, if you're trying to get a job that requires a license, you could have an issue.
So when you file your documents with the court, the judge may or may not hold a hearing in your case. So once you file your petition, the court is required to notify the law enforcement agency that was involved in your court case and the prosecuting agencies that you have filed a petition to seal your records. We do advise that you also send a letter with a copy of the petition to the prosecuting attorneys in your cases that asks them to sign a stipulation agreeing to seal the record. If the prosecuting agency agrees to seal your record and sends you that stipulation, you can ask the court to order your record sealed without a hearing. If the prosecuting attorney does not object, but also does not agree, the prosecuting 30 days after the prosecuting attorney has been notified, you can ask the court to seal your record without a hearing. So again, once that 30-day time period has passed. You will have a hearing if the prosecuting attorney objects. At that point, the judge will likely schedule that hearing, and they'll want to have you come in and explain why you want the record sealed. And the prosecuting attorney will also be afforded that opportunity as well to appear and explain why they object to you sealing your record.
And this is one of the main changes in the law from AB 219 from this past legislative session. Essentially, it made it a little bit faster, I guess. The goal was to try to speed up the ability to process petitions to seal records. And it also made the presumption to seal the record a little more forceful. So in the past, if you filed a petition and the prosecuting attorney didn't do anything, they just let it sit, 30 days, 60 days, whatever it is. There was actually a rule in Washoe County that said they had 21 days to respond. Now it actually sets a limit across the state saying they have 30 days to respond. If they don't respond, you can move forward. So this is a little bit of a change. It also, we're going to talk a little bit more about the presumption in a minute, but it did allow for the sealing of a record without a hearing if the prosecuting attorney does nothing. Whereas before, hearings had to be scheduled in all of those cases. The judge can simply order your record sealed if the prosecuting attorney is silent. So that's the biggest change here with the hearing. And we're going to get into a little bit more about the actual process because there is a big difference between Clark County and Washoe County, or the North and the South. So we'll get into that in a little bit.
So now we'll talk more about that presumption that Ray was just talking about. So pursuant to Nevada law, there is a presumption in favor of record sealing, which of course is designed to promote your second chance at a future without a criminal record holding you back. That presumption shall be applied where the prosecuting attorney stipulates to seal the record, but that presumption can be rebutted. If the prosecuting attorney objects to your petition, like we just mentioned, you will have a hearing. If at that hearing there is insufficient evidence presented by the prosecuting attorney to rebut that presumption, the court shall apply that presumption and seal your criminal record. However, if there's no stipulation and the prosecutor doesn't object, the court should apply the presumption but may seal your record. So it's not a shall, it's a may. Again, that presumption must be rebutted. Therefore, without evidence to rebut the presumption, the court should seal your record. And lastly on here, if the court denies the sealing, you may file an appeal.
So just a final note about the appeal. In the law before, this was one other change. You did have, essentially there was a scheme to file another petition to get a rehearing. You could only file two. That is no longer in the law. You file one petition. If you are unsuccessful in sealing your record, you do have to appeal it. So you do not get a second chance to file a petition. So please be aware if you lose, you do have to file an appeal, and appeals can be very difficult. So feel free to reach out to us for more assistance, or another attorney, or just try to get some more information on the appeals process, because that can be a very difficult process.
And as Ray mentioned, briefly touched on previously, there are still certain agencies that have the ability to see your sealed record. But again, this is under limited circumstances. So this is in NRS 179.301. Those agencies are the Nevada Gaming Control Board, the Division of Insurance of Department of Business and Industry, the prosecuting attorney, the Central Repository for Nevada Records of Criminal History, the State Board of Pardons Commissioners, and some professional licensing boards with diversion courts. But when I tell my clients this, I think everyone kind of gets freaked out because they think that their landlord or just their employer that isn't one of these agencies will be able to see the sealed record. And I just explained to them that only what's on the slide, those are the only agencies that can still see a sealed record. Just your normal everyday landlord or normal everyday employer will not be able to see your sealed record. And also, if you're successfully able to seal your record, that information is going to be taken off of public access. So someone off the street won't be able to, search your name in the court websites and pull up the court case information. Just know that only these agencies will still be able to see your sealed record. And I think, Ray, is this where you're going to take over?
Yes, I think so. Okay. All right. So we're going to start talking about the process. We just basically went through sort of the rationale behind sealing your record. We talked about the presumption that, this should be in favor of sealing to give people second chances. So the sealing should be done unless the presumption is rebutted. There's evidence to show why you should not have your record sealed. So now we're going to start talking about the mechanics of actually what do you need to do in order to get your record sealed. So this is, I'm not going to go over the list, but this is essentially the process in a list form, what you need to do from start to finish. So we'll go ahead and get started with gathering your required documents and preparing for the process. So the first thing that we always advise people to do is get as many free resources, free records that you can before you start this process. Some with e-filing comes electronic records of court cases, and in e-filing jurisdictions like Reno, Sparks, Las Vegas, the 8th Judicial District Court, the 2nd Judicial District Court, which is Washoe County, Clark County, this information is available to you online. In most cases, it is free. I don't know exactly what the Clark County courts have, but I know that for the most part, you can't get any details. You're not going to be able to pull up, say, the actual documents. In most cases, you have to be a lawyer to do that. But you can at least get a docket summary. In a lot of justice court cases, the information is actually pretty substantial. You can get information about when your case was closed and things like that. That's an important thing because, as Liz was talking about with eligibility, you do have to start the clock from when your sentence was completed. So you do need to know the actual date that you were released from custody, that you were discharged from probation or parole, that the date that you completed whatever that last thing on your sentence was. And that information is often found in the court records. So it is important to start by getting all of the free information that you can that's available to you. And just remember, if you're still under a sentence, you have an open case, you have an active warrant, you are not going to be able to seal your record. So you do have to, wait that time after you finish your sentence, not after you were arrested or convicted. The big thing is, of course, is stay out of trouble. If you get an intervening conviction, that's going to restart the clock on essentially when you can seal records. So it's really important that we're really looking at you are, putting your past behind you, moving forward. This criminal history is something that happened to you, within that time frame, and you haven't been engaging in criminal activity in the present. As Liz said, if the prosecuting attorney objects, you will have a hearing. It's important that you have a good reason or be able to give the judge a reason why you should have your record sealed. Oftentimes we ask people if they volunteered in their community, if they're working, if they finished school, what their hopes are for the future, were there circumstances in the past that they've overcome and are showing, that they're moving forward. Again, this is really just the ability to tell the judge why they should seal your record if somebody's going to try to present evidence that you shouldn't have your record sealed. And then, like I said, collecting records, which we're going to talk about now. So the only document that's required to be attached to your petition is the criminal history report, the official background check that you order from the Department of Public Safety. There might be reasons why you want to attach other documents. It is common in Clark County to attach the scope. It is not common in the north to do that. What's more common is to attach things like if you, we're going to talk about what court to file in slightly. If you file in a district court to try to seal records from other courts, you might want to include the court records from that case so the judge doesn't have to go questioning whether or not what you put on your petition is accurate. So it is important not only just to collect free records, but to potentially attach those to your petition. So again, you're going to need potentially the document that discharged you from probation or parole, records from the Department of Corrections when you were released from prison. The criminal history report can often also contain inaccurate information. So you will need that backup documentation if, say, the information in the criminal history report actually has a date that's way past the date that you are actually released. So again, in Clark County, you should request your scope. One of the things that we do say is that it is pretty important really to try to get whatever free records or initial records you can before you request your criminal history report, mostly because the criminal history report does become stale. The timeframes north and south are different. In the north, your criminal history report will get stale. Anytime after 30 days, the court can potentially object. Usually we see around the 60-day time frame when things start getting questioned. So it's really important that you are prepared to file your petition the minute you get your criminal history report back from the Department of Public Safety. The Department of Public Safety likes to say the criminal history report is stale the day you receive it. It is already out of date because, of course, the mailing time it took to get it to you means that you could have obviously engaged in additional criminal history. So it is really important to be prepared to file your petition as soon as possible after you get your criminal history report. And I don't know, Liz, is in the South, how long are judges allowing criminal history?
So long as the CHR isn't older than 1 year, we've never encountered any issues with it. So we always tell our clients here in the South, make sure it's not older than 1 year.
Yeah, in the North, it's a little bit different. It's been a while since we've actually had anyone challenge the date of one when we filed it. But I would say anything over 2 months and you might have a problem. I'm not saying don't file. You can just request another CHR if somebody objects. But it is important, to really listen to what I'm going to say next, which is get the free records you can to start filling out your petition as soon as possible, because once you get your criminal history report, you should be ready to file. So we talked about going to the free resources on the court's websites. We're going to talk a little bit about what documents you might need to get. If it's a gross misdemeanor or a felony, your judgment of conviction is what's going to have the sentence information on it. And that's important to know, this is what you were sentenced to, whether you were sentenced to prison, probation, the timeframes involved. Again, I mentioned getting your discharge papers from parole and probation because it is your discharge date from parole and probation, which starts the clock when you are actually on parole or probation. If you finish your sentence in prison, you can, if you don't already have a copy of your discharge papers, you can try to get that from the Department of Corrections. I would say that's not probably as important as the rest of it. But it is important if somebody objects, if they're questioning your time frame, that you have proof of the date you completed your sentence. Again, as I said, court docket sheets, a lot of times those are free. Some courts do charge for additional records, but oftentimes the actual docket sheet or case summary is free and actually provides a lot of information. So start with that, start with as many free records as you can get. And then, as I mentioned, in Clark County, you will need to get your scope. You don't necessarily need to run police reports from other counties, But if you want to be comprehensive about all of your arrests, then you would need to get police reports, although police reports do cost money. Again, as we've said, we're talking about Nevada state criminal history. So the criminal history report you order from the Department of Public Safety is your Nevada criminal history. It will indicate on the criminal history report whether you have criminal history from other states. Be aware that that could potentially be an issue. You might want to request your FBI report if you're worried that you have intervening criminal history from other states. But that criminal history from other states cannot be sealed in Nevada. So you would need to deal with that as Liz mentioned, call a legal aid office in the other state. But we're only talking about criminal history in Nevada. Again, we've talked about the expiration date. Please be careful. If you're going beyond 60 days outside of Clark County, you might be having some issues. In the South, it is a year. Or at least we haven't had problems if it's been a year. I should clarify that. It can also take some time to process your request. So if you're sure that you are eligible, that things have been, it's been 20 years since you were involved in anything, you can go ahead and request your criminal history report. I would suggest, though, that you still go and try to collect all the free resources you can, because criminal history reports are often inaccurate. They also don't necessarily contain all the information you would need to file your petition, because they only have the information that is reported to them by the criminal justice agencies. So if a court or police department didn't report all of the information regarding your charge, you do need that court information in order to complete your petition, because again, the date you completed your sentence is the most important information that you can provide. When you're doing your application for your CHR, you need 3 things. You need the form, you need the fee, and you need your fingerprints. So there is a form. It's the DPS 006. It is available online on the DPS website. It does cost money, but you can get an extra copy for free. You just have to write on the bottom, please provide 2 copies of my criminal history record. But it does cost money to get the first one. So you do need to fill out this form. You do need to get your fingerprints. So you can get your fingerprinted at any fingerprint agency, or you can go to the sheriff's office or the police office or something and get your fingerprint card. They do have to be legible. We have had fingerprint cards rejected if it's illegible. So make sure that you're firm about pushing your fingerprints on the card. But you do need to make sure that it's also filled out correctly. We have had them rejected if the card itself doesn't contain your name, date of birth, place of birth, identifying information in your signature.
And also, Ray, just one note on the fingerprint card. I did recently have one of my clients' fingerprint cards rejected by DPS because it was older than 1 year, which makes no sense because our fingerprints don't change in time. But for whatever reason, just make sure that your fingerprint card, again, isn't older than 1 year. Yeah.
And then I said, again, it's $27. It does cost $27. It will need to be paid by a money order or certified check, so certified funds in some manner. Make it out to the Department of Public Safety, and then obviously sign it if there's a signature line. And there is no fee waiver for this, so you do need to get the $27. And you also need to pay for your fingerprints. Whatever the fee is for the fingerprints, you would need to pay that. So there is some cost for getting this, which is why I suggest get the free records first. And then you just need to submit it to the Department of Public Safety, staple all of it together. Make sure that, where you staple it for the fingerprint card, do not staple it over the fingerprints, staple it in the corner. And make sure that you put everything is in there. So the form, the fingerprint card, and your money order or certified check. And then you just need to mail it to the Department of Public Safety. And there's an address on the DPS 006 form. And of course, it's going to take 4 to 8 weeks to process.
Okay, so I'll take it over from here. So now we're going to talk about how you prepare the petition. So once you have your CHR, your scopes, and any of the supporting documentation that Ray just talked about, you now have to prepare your petition, which is what you'll be filing with the courts. So once you get to this step, it's really important that everything is accurate on the petition and that you have all of the correct information. So one quick note about preparing the petition. If you have if you were in court cases in several different courts, so say you were in justice court and municipal court, it may be easier to file one district court petition that's comprised of all of your court cases versus filing petitions in each specific court. I think we're going to go over it in a few slides, but there are filing fees whenever you do file something with a court. The district court filing fee is $270. The justice court filing fees, at least here in Southern Nevada, are all $74, and the municipal court filing fees are all $71. So sometimes you may save money by filing in district court, but sometimes it might just be cheaper to file individually in each court. So you'll have to just calculate the filing fees to make that decision. And of course, there is a fee waiver if you are unable to pay those filing fees, which I believe we're going to get to later in the presentation. So on the petition, you have to indicate any and all aliases that law enforcement knows you by. So to figure out whether or not you have any aliases, you're going to look at the top of the CHR and the top of the scope. Both of those documents have a section that says AKA. If you have any aliases, those are going to be listed under that AKA section, and you'll have to be sure to include those on your petition as well. So once you have the CHR scope and those supporting documents, we recommend that you make a list. This list is going to save you time in the future when you're actually drafting your petition, and it keeps everything really organized at this point. So make this list and make sure that all of the following information is included on that list. Put the date of arrest, the arresting agency, the original charge, the court case number, and the final disposition for each case. The disposition basically just means, how did the case end? Did you plead guilty? Was the charge dismissed? Did you plead to a lesser charge? You want to indicate that on your list. All of that information should be found on your CHR scopes and your supporting documents, but if some of this information is missing, you will have to search your name on the court websites to fill in any gaps. One of the other pleadings that you need to file with the court is called a declaration. This is a statement that you make under the penalty of perjury. The declaration is basically your opportunity to talk to the judge and tell the judge why you want to seal your criminal record. So even with that presumption that we talked about previously, you still want to include facts about how you've turned your life around, as well as the positive things that you're doing in your life right now. And then also you may want to address the mistakes that you made in your past and how you've moved past them. We don't recommend that you discuss any of the underlying charges themselves. So don't talk about the facts of, why you did what you did, or, bring up the judge or the police. I tell my clients this is supposed to be a happy document. Focus on the positives. Tell the judge how great of a person you are now and how your life has really turned around. But again, don't discuss the underlying facts of your court cases. Just a couple other notes on that. I also tell my clients, if you have any church activities that you're involved in, any volunteer work that you're doing, those are things to mention in that declaration. If you're experiencing any challenges, either finding housing or finding a job, I think almost all of my clients have challenges finding employment with the criminal record. That's something that you want to put in the declaration as well.
So we do have a question. I think maybe just pause. There is a slide at the end to take questions, but there's one question that directly addresses the declaration. So I thought we'd answer it. Is it required to attach the declaration? It is not, but I strongly suggest you do so, because if the prosecuting attorney objects, you want to give the judge as much information as possible to seal your record. And there's also, because, you know, there's a difference between may and shall. If there's no response and you're going to be submitting your petition to the judge to sign the order without a hearing, it is a good idea, again, as Liz said, let's give him or her the best information you can, the best reasons, the happy reasons why they should see the record. So we suggest in cases that you provide a declaration to the court addressing that. If your discharge was dishonorable, if you have a probation or parole dishonorable discharge, the presumption does not apply. So there is no presumption that you should have your record sealed. That has to be rebutted. The judge has basically discretion as to whether or not they can order your record sealed. Again, you want to give the judge as much information as you can to, you know, to convince them that you should have your record sealed, that you've moved, this was your past, you've moved on with your life. And again, we don't suggest providing any dispute or information about the criminal charges themselves. Talk about what's going on in your life now. Just two other questions just to address at the moment. Does it matter what the charge is? So we did talk about eligibility earlier. It does matter. There are some ineligible charges. Other charges, you know, whether or not you can seal them does depend on how long the statute gives you to file your petition. So it does matter what the charge is and where it falls in that time frame. And then, can you file the petition to seal at the court and then e-file the rest of the documents? Yes, you can. You can paper file and then e-file later if you sign up later. You know, that's completely up to you. And what the court allows you to do, I should say. Of course, require e-filing. So, okay. Take it away.
So for some sample petitions, feel free to visit our website, which is nevadalegalservices.org. For Northern Nevada, we do have on our website templates, Word documents that you can download and fill out yourself. And if you're in Southern Nevada, we have an amazing self-help interactive forms filing process generator on our website. So you'll go to our website, you'll click on Know Your Rights and then Criminal Record Sealing, and it'll take you to the generator to make all of your pleadings. You'll have to first select the court that you'll be filing in, and then the generator will take you through a series of questions that you'll answer. And then depending on your answers, your pleadings will be drafted, and you'll get a really convenient Microsoft Word document of all of your pleadings with that generator.
So just a quick note about the website. This is a new website. The forms are available on the website. So as Liz said, you go to Know Your Rights. We actually have a new section called Forms Library. So you can go to that forms library and download the form for the North, or click on the links to start the interactive process for the South. But please be aware, this part of it is fine. You can access it on our website. There might be other parts of our website that we're still working on and still updating. So it is currently in our soft launch and a work in progress. But I wanted to make sure that we gave everybody the new website and made sure that you guys knew that the forms were on it. So please feel free to check out our new website, and definitely, if you need to, use our resources.
So after you file your petition and attach your CHR and any other documents regarding your criminal history, you will need to send a copy of your petition with a request to each prosecuting attorney to sign a stipulation or the proposed order. The prosecuting attorney can agree and sign that stipulation and proposed order, or the DA can refuse to sign it and just oppose you sealing your record altogether, or the DA can refuse to sign because corrections are necessary, and the DA will include a letter. They'll provide you with a letter that indicates what corrections you have to make on your pleadings. There is a change in AB 219 that now restricts the time for the prosecuting attorney to respond to 30 days. If the prosecuting attorney does not respond, you can submit an order to the court, which we already touched upon. Some prosecuting attorneys won't review the documents at all, as in Washoe County, and Ray can talk a little bit more about that. The Clark County DA, however, they prefer to review the petition before you file your documents with the court. So it's not necessarily a requirement that you send them the documents before you file with the court, but that is how we normally do it for our clients, just so that they have the opportunity to review before everything's actually filed with the court clerk.
And so this is probably one of the biggest distinctions between Clark County and I don't know if you filed much in Nye, but pretty much the rest of the state is the requirement to submit it to the district attorney beforehand. We do not do that in the North, especially with Washoe County, because the DA won't review it. They just won't review it. Now the law with the change says that they have 30 days to review it, and if they don't, you can submit it to the judge with an order. My feeling is the law changed. The statute says there's this 30-day time limit. If you file your petition and there's no response in 30 days, submit it to the judge for the order. Obviously, Clark County is different. We can have a discussion about whether or not you should still pre-submit it. I don't know how long the Clark County District Attorney usually takes to review the petitions. But again, the law change was designed to make this process quicker. So I definitely would hope that it doesn't take a long time for, any review process. I will also, Liz, I'll let you weigh in, but Liz does also do a much more specific process for Clark County. That presentation is on Fridays. It's in partnership with the UNLV Boyd School of Law. So if you do want way more in depth on how to file, you can definitely attend that and get some more information on this process in Clark County. But I don't know, Liz, if it takes a lot longer or if it's, they're pretty good about it. Again, you want the DA to agree if they can. So
yeah, the DA tends to take a while here in Clark County. They take about 10 to 12 weeks. The city attorney, they're faster, but it does take a couple months if you do opt to send them those pleadings before filing. So yeah. I definitely like this change of the law. I think it's going to expedite things for our clients, and it just removes one step, but there's so many steps in this process that we'll take it.
Yeah. I agree. It's a really encouraging sign that they're trying to make it easier for people. Please just, do remember, this is our legal information, our opinions. If you do get the prosecutor to agree, it is a shall seal. The judges, are required to apply assumption. If the prosecutor is silent and doesn't do anything, you are just submitting it to the judge to review for the order. So it is, you can weigh what you would prefer in terms of the process, having the prosecuting attorney agree or filing and dealing with this as quickly as possible. So it, could depend on the judge, it could depend on the court. And of course, we're primarily talking about Southern Nevada. Most of the process in the other courts is more in line with the statute.
So will you have a hearing? So as we touched on briefly, if the prosecuting attorneys for all of your charges have signed that stipulation and signed the proposed order, then you will not have a hearing, which is great news because that means that the judge will sign your order, and that's the biggest challenge of this all. So if that happens, that's the best case scenario. If the prosecutor does not respond within 30 days, the hearing is not required. If the prosecuting attorney has opposed your petition, then you will have a hearing, which will give you that opportunity to tell the judge why you want to have your record sealed. And submitting the order. So you will be responsible for submitting the order to the judge to sign in most cases. There will be a process for submitting the order to the court. If you have any questions, you can call the court clerk for assistance, but you will need to submit the proposed order through the e-filing program in jurisdictions that do require e-filing. And some judges do have a separate process, so you may need to be aware of that process by looking at the court websites. It kind of depends on what jurisdiction you're in and then what judge your case is ultimately assigned to. And technical filing issues. So some courts do have e-filing, such as District Court, Las Vegas Justice Court, and Reno and Sparks Justice Courts. I prefer e-filing. It's a lot easier to just do everything over your computer, but some courts are still, in the 80s, I guess, where they don't have e-filing. So those are Henderson, North Las Vegas Justice Court. In most rural courts don't have an e-filing system. So if that's the case, you're going to have to go to the court clerk and file everything in person. When you do go to file your pleadings, most courts will also require that you file a cover sheet, which is called a civil cover sheet. That is available online. When you go to file your documents as well, as I mentioned previously, you're either going to have to pay that filing fee, or you can file what's called an application to proceed in forma pauperis, which is a really fancy term for a fee waiver. If the court clerk grants that fee waiver, you won't be responsible for paying that filing fee. However, if the court clerk denies the fee waiver, usually they give you about 2 to 3 days to pay the filing fee, or else they're going to mail you back your documents. We also recommend that you request certified copies of the order after the judge signs it. So this, of course, is, once you file your documents, the judge is going to review them. If the judge signs that order to seal records, you're going to need to obtain some certified copies of that order to send to certain agencies, which that will let them know that the judge has signed the order. And at that point, they'll have to comply with that judge's order and seal your record. So we recommend that you do request those certified copies after the judge signs it. Some people request it when they go to initially file the documents, but the disadvantage with that is if the judge doesn't sign the order, you're essentially paying money for nothing because you won't have any certified copies of the order to get. So just request those certified copies after the judge signs the order. And lastly on here, we do have instructions on our website for filling out the petitions. Really all of this information we have in our criminal record sealing manual, which we do, I believe, Ray, that the new website does have the manual on it as well. Or we will be adding it shortly if it doesn't. That's a better answer. So feel free to go onto our website and look out for that manual. It details all of these steps, so you can refer to that as well. So your options at this point. So if you have obtained the documents that we talked about, so if you have your CHR and your scopes and your supporting documentation, and you would like to see if you qualify for free legal assistance, you can complete an intake with our office. We do have an option to complete an online intake on our website, which Ray said, our new website is nevadalegalservices.org. You can also call our offices and mention to the receptionist that you do want to complete an intake. Our Reno office's phone number is 775-284-3491. And the phone number to our Las Vegas office is 702-386-0404. In regards to in-person intakes, due to COVID, we just ask that you please call our offices to see if we could do a virtual or telephonic intake. That's preferred at this point. So with that said, does anybody have any follow-up questions for Ray or I?
We'll go ahead and leave this open for a couple more minutes. If you guys have any other questions that you'd like to ask, please feel free to post that again in the chat. But this will also obviously be available on our YouTube channel. If there's anything that you would like to review. And we will be updating the information. The website information right now has the old process. That information will be updated after October 1st to have, you know, the information that we talked about the law change that will go into effect October 1st. And we'll include some more information, like hopefully the instruction manual, because I don't think it's on the new website right now. So we'll be updating that hopefully in the next week. But with that said, it looks like we have no further questions. So thank you, Liz, for joining us today for our Thursdays Live with Nevada Legal Services.
Thanks for having me.
I hope you do this again.
Sounds
again,
good.
again, our next presentation will be the second Thursday in October. And we will have a new topic to discuss. So please feel free to join us then. But thank you, everyone, and have a great rest of your day.